Starting a business without the right legal documents is like building a house without a foundation. You might get the walls up, but when the first storm hits, everything comes crashing down. Today, we're going to walk through the essential legal documents that every small business owner needs to protect themselves, their assets, and their future. These aren't just fancy papers that lawyers push on you. These are your shield against lawsuits, your roadmap for growth, and your ticket to being taken seriously as a real business. By the end of this video, you'll know exactly which documents you need, when you need them, and why they could save your business thousands of dollars down the road. Chapter 1. Formation documents that make it official. Once you pick your business structure, you need to file the right documents with your state to make it legal. Think of this as your business birth certificate. For an LLC, you'll file articles of organization with your state's Secretary of State office. This document includes your company name, your business address, and the name of your registered agent. The registered agent is the person who receives legal papers on behalf of your company. This is crucial because if you get sued and they can't find your registered agent, you could lose the case without even knowing about it. For a corporation, you'll file articles of incorporation. This document includes similar information, but also details about your company's stock, like how many shares you're authorized to issue. Let's look at Georgia as an example. You can file online or by mail. The state provides specific forms like the Articles of Organization for LLC. You'll pay a filing fee, and the state will process your paperwork. Once approved, your business officially exists as a separate legal entity. But filing with the state is just the beginning. You also need federal and local registrations to operate legally. You'll need an employer identification number, or EIN, from the IRS. Think of this as your business social security number. Even if you don't have employees, you'll likely need an EIN to open a business bank account. You'll also need a local business license from your city or county. This gives you permission to operate in that specific area. And if you're in a regulated industry like food service or construction, you'll need additional professional licenses. If you need help with any of these steps, I have provided a link in the description below to an easy-to-use service that will walk you through the step for each document you need. Now, getting the formation documents right is just step 1. Next, we need to talk about the internal rules that actually govern how your business operates. Chapter 2, Internal Governance Documents. But really quick before I move on, if we haven't met yet, I'm Sean's clone, a licensed tax professional who personally researches and writes every script you see from me. And while Sean is helping people save on taxes, I'm here to share his knowledge with you. But if you have any questions, the real Sean reads every single comment and tries to respond to most. All right, let's continue with Chapter 2, Internal Governance Documents. Your state formation documents create your business, but they don't tell you how to run it. That's where internal governance documents come in. These are like the constitution of your company. For an LLC, you need an operating agreement. Most states don't legally require this document, but that doesn't mean you should skip it. Without an operating agreement, your state's default LLC laws will govern your business. These one-size-fits-all rules might require unanimous consent for every decision or split profits equally regardless of how much each person invested. A good operating agreement covers who owns what percentage of the company, how profits and losses are shared, how decisions get made, and what happens if someone wants to leave the business. It also spells out whether the LLC is member managed, where all owners participate in daily operations, or manager managed, where you appoint specific people to run the company. Even if you're the only owner, you still need an operating agreement. This document helps prove to a court that your LLC is a real business, not just your alter ego. Without it, a judge might pierce the corporate veil and hold you personally liable for business debts. For corporations, you need corporate bylaws. Unlike operating agreements, bylaws are legally required in most states. Bylaws are more formal and structured than operating agreements. They focus on corporate governance procedures like how to hold board meetings, how to elect directors, and what powers the officers have. Bylaws cover things like how many directors you need, how often you'll hold meetings, what constitutes a quorum for making decisions, and how you'll handle indemnification of directors and officers. The key difference is that an operating agreement is a contract between the LLC members, while bylaws are rules adopted by the corporation's board of directors. Here's what most people don't realize. These internal governance documents are your first line of defense against losing your liability protection. Courts look at whether you treated your business like a real separate entity. Having proper governance documents and following them shows you're serious about the separation between you and your business. Without these documents, you're flying blind when disputes arise. And speaking of disputes, let's talk about the documents you need when you start hiring people. Chapter 3, Employment and hiring documents. Nothing can sink a small business faster than employment law violations. The rules around hiring, classifying, and managing workers are strict, and the penalties are severe. The first critical decision is whether someone is an employee or an independent contractor. This isn't a choice you get to make based on what's convenient. The law determines the classification based on how much control you exercise over the worker. An employee is someone you control in terms of how, when, and where they do their work. You provide training, set their schedule, and give them the tools they need. You're responsible for withholding taxes, paying unemployment insurance, and providing workers' compensation coverage. An independent contractor is in business for themselves. They determine how to accomplish the task you've hired them for. They use their own tools, set their own schedule, and handle their own taxes and insurance. The biggest mistake small business owners make is having someone sign an independent contractor agreement and thinking that settles the classification. The agreement doesn't matter. What matters is the reality of the working relationship. If you treat someone like an employee but classify them as a contractor, you could face massive back taxes, penalties, and wage and hour lawsuits. When you do hire employees, you need proper documentation. Start with a job offer letter that outlines the basic terms like salary, start date, and job title. Then follow up with a comprehensive employment agreement. A good employment agreement includes the job responsibilities, compensation, and benefits, an at-will employment clause that allows either party to end the relationship at any time, confidentiality provisions to protect your trade secrets, and intellectual property clauses that ensure any work created by the employee belongs to the company. Don't forget about non-compete and non-solicitation clauses. These prevent former employees from working for competitors or stealing your customers and other employees. Just make sure these clauses are reasonable in scope and duration, or courts won't enforce them. You'll also need an employee handbook. This isn't just a nice-to-have document. It's your legal shield against employment disputes. The handbook should include your equal employment opportunity policy, anti-harassment procedures, leave policies, code of conduct, and wage and hour policies. Every employee must sign an acknowledgement that they received and understand the handbook. This signed form can be your best defense if an employee later claims they didn't know about a policy. There are also mandatory federal forms you must complete for every new hire. Form I-9 verifies that the employee is authorized to work in the United States. Form W-4 determines how much federal income tax to withhold from their paychecks. For contractors, you'll use Form W-9 to get their taxpayer identification number. Getting employment documentation right protects you from government audits and employee lawsuits. But you also need to think about the contracts that generate your revenue. Chapter 4, Customer and Vendor Contracts. Every business transaction should be governed by a written contract. Handshake deals and verbal agreements might feel more personal, but they're recipes for disaster when things go wrong. For service businesses, you need service agreements. These contracts should include a detailed scope of work that spells out exactly what services you'll provide, what deliverables the client will receive, and when everything will be completed. Be as specific as possible to avoid scope creep, where clients demand more work than originally agreed upon. Include clear payment terms with the total fee, payment schedule, and penalties for late payments. Specify the term of the agreement and the conditions under which either party can terminate early. Don't forget about intellectual property clauses. Who owns the work you create for the client? If you're designing a logo or building a website, make sure the contract clarifies ownership rights. For businesses that sell products, you need sales agreements. These should describe the goods being sold in detail, including quantity and specifications. Include the price, payment method, and delivery terms. Specify who's responsible for shipping costs and what happens if products are damaged in transit. Include warranty information and return policies. Be clear about what guarantees you're making about the products and how defects will be handled. On the flip side, you need contracts with your suppliers and vendors. These relationships are just as important as your customer relationships, but they're often overlooked. Vendor agreements should include detailed performance standards and quality requirements. Set firm delivery deadlines with consequences for delays. Include indemnification clauses that require the vendor to cover any losses you suffer due to their negligence or failure to perform. Require your vendors to carry adequate insurance and provide proof of coverage. Include termination clauses that let you end the relationship if the vendor fails to meet their obligations. Remember, in vendor relationships, you're the customer, which means you often have more negotiating power than you realize. Don't just accept the vendor's standard contract terms. Negotiate clauses that protect your business. Well-drafted contracts prevent disputes by setting clear expectations up front. They also provide a roadmap for resolving conflicts when they do arise. But contracts aren't the only way to protect your business assets. Chapter 5, protecting your intellectual property. Your business's most valuable assets might not be physical. Your brand name, your innovative processes, your creative content, and your customer relationships are often worth more than your equipment and inventory combined. Protecting these intellectual property assets requires specific legal documents. Start with non-disclosure agreements, or NDAs. These contracts create a legal duty for anyone who receives your confidential information to keep it secret. Use NDA before sharing sensitive information with employees, contractors, potential investors, or business partners. A strong NDA clearly defines what information is considered confidential. This might include trade secrets, business strategies, financial data, customer lists, and proprietary processes. The agreement should specify how long the confidentiality obligation lasts and what happens if someone violates the agreement. The real power of an NDA is its deterrent effect. It signals that your information is valuable and that you're serious about protecting it. Most people won't risk a lawsuit by violating a clear, well-written NDA. Next, protect your brand with trademark registration. A trademark is any word, name, symbol, or logo that identifies your business and distinguishes it from competitors. While you get some limited rights just by using a name in business, these common law rights are weak and geographically limited. To get strong, nationwide protection, register your trademark with the U.S. Patent and Trademark Office. The process starts with a comprehensive search to make sure no one else is already using a similar mark for related goods or services. Then you file an application that specifies your mark and identifies the exact goods or services you'll use it for. The USPTO will examine your application and publish it for opposition, giving other trademark owners a chance to object. If everything goes smoothly, you'll receive a registration certificate that gives you nationwide exclusive rights to use the mark. Federal trademark registration transforms your business name from a simple identifier into a valuable piece of property that you can license, sell, or use as collateral. For creative works like website content, marketing materials, software code, and product manuals, you need copyright protection. Copyright exists automatically when you create something original, but to enforce your rights in court, you need to register the work with the U.S. Copyright Office. The registration process is straightforward and inexpensive. You complete an online application, pay a small fee, and submit a copy of the work. Once registered, you can sue infringers and potentially recover significant damages and attorney's fees. If your business involves genuine innovations or inventions, consider patent protection. Patents give you the exclusive right to prevent others from making, using, or selling your invention for up to 20 years. But patent applications are complex and expensive, usually requiring a patent attorney. Most small businesses should focus on trademarks and copyrights first, then consider patents for core inventions that provide a real competitive advantage. Intellectual property protection isn't just about legal rights. It's about building valuable business assets that can drive revenue and growth. But there's one more area of legal compliance that's absolutely critical in today's digital world. Chapter 6, website legal documents. If your business has any online presence, you need specific legal documents on your website. These aren't optional extras. In many cases, they're legally required, and failing to have them can result in massive government fines. Every business that collects personal information from website visitors needs a privacy policy. The threshold for collecting personal information is extremely low. If you have a contact form, newsletter sign up, or analytics tracking, you're collecting personal data like names, email addresses, and IP addresses. A growing number of laws require privacy policies, including the California Consumer Privacy Act, Virginia's Consumer Data Protection Act, and the European Union's General Data Protection Regulation. These laws apply even to small businesses if they collect data from residents of those jurisdictions. Your privacy policy must clearly explain what personal information you collect, why you collect it, how you use it, who you share it with, and how long you keep it. You must also explain users' rights like the right to access, correct, or delete their data, and provide instructions for exercising those rights. The privacy policy must be easily accessible from every page of your website, usually through a link in the footer. Update the policy whenever you change your data practices and notify users of significant changes. Unlike other business documents that protect you, the privacy policy is designed to protect consumers. The primary enforcement risk comes from government agencies like the Federal Trade Commission, which can impose substantial fines for non-compliance. You also need terms and conditions, sometimes called terms of use or terms of service. While not legally required, this document is essential for protecting your business from liability and controlling how people use your website. Terms and conditions allow you to limit your liability, protect your intellectual property, define acceptable user behavior, outline payment and refund policies for e-commerce sites, and specify which state's laws govern disputes. The agreement should prohibit users from copying your content, spamming other users, posting illegal material, or using your site for harmful purposes. Include the right to terminate user accounts for violations. For e-commerce sites, include detailed terms of sale covering payment processing, shipping policies, return procedures, and warranty disclaimers. Consider requiring disputes to be resolved through arbitration rather than court litigation. Arbitration is often faster and less expensive than traditional lawsuits. Make sure users actually agree to your terms and conditions through a clear opt-in process, like checking a box during account registration or before making a purchase. Website legal documents create a controlled legal environment around your online business. They're your primary tool for managing user behavior and reducing liability in the vast, unregulated space of the internet. Now that we've covered all the essential documents, let's talk about how to implement them strategically. The bottom line is this: legal documentation isn't something you do once and forget about. It's an ongoing process that evolves with your business. Remember the importance of ongoing legal compliance. Keep all your registrations and filings current, including annual reports with your state and trademark maintenance with the USPTO. While templates and online resources can help you understand these documents, don't try to go it alone for the most critical items. Click the link below for online resources that make this process easy, because the legal framework of your business is its foundation. Without proper documentation, you're vulnerable to lawsuits, internal disputes, and regulatory problems. But with the right documents in place, you have the stability to weather challenges, the clarity to operate efficiently, and the legal protection to build lasting value. These documents aren't just paperwork, they're the tools that transform a hobby into a real business. And there has never been a better time in history to start a business. If you're looking for new ideas, coming up next, I have a video on 5 passive income ideas powered by Big Beautiful Bill, so consider watching that now. As always, thanks for watching, and I'll see you in the next video.